I beg to mention item number 34 of today's list, Lordship. My Lord, Mr. Justice Goswami may not like to take up this matter. Lordship, I further pray that this may be posted in the last week of February. Senior counsel, Mr. Mishra, is not keeping well.
Yeah, since my brother can take up the matter,
Lordship.
we can't pass any orders. We'll
Lordship.
say we'll list this case before any other bench without one of us. Within bracket, justice. Okay.
Obliged, Lordship.
Thank you, Your Lordship. With the consent of the other side, I beg to mention item number 32 and 33. Respondent advocate, respondent number 2, 2, 4, 2, 3, and 4, advocate Mr. Ardube is out of station, Lordship.
Who appears for the other side?
M. Borgohain.
Okay, heard MS M. Borgohain and a counsel for the petitioner. On request made on behalf of Mr. Ardube. You are praying for?
Respondent number 2, 3, and 4.
Appearing for the respondents 2, 3, and 4. When do you want?
Lordship, after 2 weeks, Lordship.
List after 2 weeks.
Obliged.
May it please your Lord.
Oh.
Lordship, I pray for listing of a review application, Lordship. Lordship, in this matter, what has happened, Lordship? The Honorable Chief Justice, Lordship, Sandeep Mehta has been elevated. And thereupon, Lord, when this bench was constituted, Justice Susmita Puravan has said that she won't be taking up this matter. So, Lordship, a bench would have to be constituted. So, Lordship, may I pray, Lordship, any date convenient to my Lord?
Okay. Next week is full, no? Yes, 16th.
16. Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 24 to 27. I have taken the consent of other side, my lord. In this case, my lord, I have been newly appointed as a standing counsel and chief autonomous counsel, my lord, education department. So I need some time to go to the records, my lord. I have not received the report.
You are appearing on behalf of all the appellants.
24, 25, and 27, Lordship.
Okay. On request made by Mr.
RR Kaushik.
R. Kaushik.
RR Kaushik.
R. Kaushik. Learned Standing Council,
NC Hill, additional standing counsel, NC Hills autonomous
Additional Standing Council, NC Hills.
education department
NC Hills. When do you want?
after vacation.
List after the winter vacation.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 31. Lordship, we have taken concern from the other side, Lordship. Mr. Counsel, A.K. Prokester is on leave, Lordship. He's on leave, Lordship.
He's on leave.
Yes, sir.
Okay, on request made on behalf of AK Procastle and the council for the petition. When do you want? List in the month of January 2025.
Your Lordship, item number 28. I have to seek adjournment for that day. I have taken consent from the other part, the respondent.
You are applying for
Appellants.
appellants. Your good name?
Tanmay Majumdar, T. Majumdar.
On request made by D. Majumdar, let
Lordship.
council for the appellants.
Lordship, the date may be fixed.
You are seeking an adjournment. I can't give you a date. List after 2 weeks.
My lord, I'd like to mention listing for PIL 53 of 23, my lord. My lord, this matter is actually posted for Green Bell, Green Court. So, but then it was last fixed for, date was fixed was 39/24, but it didn't come in that day. And then commissioner was appointed, and he went and field verification was also been completed. Now, my lord, still the construction works are going on, so kindly list it as early as possible, my lord. Our matter is urgent because it is related to artificial flood.
Okay.
Here's the construction work.
11th? 11th?
My lord.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 30. We are praying for accommodation for the day.
Item number 30.
Matter may be fixed next week, Your Lordship.
I am for the
Heard Mr. B. Chakravarti, Leonard CDC for the petitioners. On request made by MS.
K. Bhattacharya,
Okay, Bhattacharya, Leonard counsel for the
respondent,
respondent. List after
next week.
1 week.
19, okay.
List after 1 week. That will do.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 2, lordship. The matter may be fixed after vacation, lordship.
Item 2.
Item 2, lordship.
Hmm. Okay, you are for the?
Appellant Lordship.
Then let him come. Okay, on request made by Mr.
P. Bordelais Lordship.
P. Bordelais and the counsel for the appellants. When do you want?
After vacation Lordship.
List after in the month of January 2025.
Lordship, another prayer for listing a PIL on 18 Lordship. Motion Lordship.
18th.
18 Lordship.
Okay.
Oblige your Lordship.
May I, may I please your Lordship? Lordship, with the consent of the other side, I beg to mention item number 14. Lordship, may kindly list the matter after vacation, my lord.
You have for?
I am for the respondent, my lord.
Anybody for the appellant? Okay, on request made by Mr.
H.J. Tamuli, my lord.
S.J. Tattamuli and counsel for the respondent. When do you want?
After vacation, my lord.
After 3 weeks.
Obliged.
May I please your lordship, my lord, I beg to mention item number 18, lordship. Lordship, I am going to file the reply affidavit, lordship. Can it be taken on lordship 13th, lordship?
You have for the
Petitioner, lordship.
petitioner. On request made by Mr.
NH Borbuyan
and his Barbara and counsel for the petitioner.
on 13th.
Well, we'll list after 1 week.
May I please your Lordship?
Hmm.
Your Lordship, case number writ petition 6921 of 2023. I pray for listing of the matter.
Is that
Before-
is that division bench matter?
Sorry, Your Honor.
Is it a division bench matter?
Yes, Your Honor.
Yeah, what is it?
Before the vacations.
Okay. 18th.
Oblige, Your Honor.
Item 1 of daily list orders.
Lordship, in this case, office note indicates that a notice has been returned answered as the address is left.
Why don't you verify the address?
Lordship, I will verify and take this step. Lordship, earlier counsel appeared, but he withdrew from the case. And case was listed for hearing.
Okay, Mr. Ezekiel Leonard, standing counsel,
Income tax. Lordship.
income tax. 1 week time or 2 weeks?
2 weeks. Lordship.
Press for 2 weeks time. To verify the proper and correct address of the
Sole respondent.
of the sole respondent. Praise the Lord. List after 2 weeks.
Lordship.
3.
Income tax department, huh? Oh, I don't know from here, I don't know.
Please, Your Lordship.
Mm.
Yesterday we have filed affidavit in opposition on behalf of respondent number 6, Lordship, which is not in record. Lordship.
Okay, MS,
S. Kemprai, Lordship.
S. Kemptile Leonard,
Yes, Lordship, respondent number 6, 7, 11, and 12.
Leonard Standing Counsel KAC submits that the respondent number 6 has filed affidavit on 5th of December. Registered to verify and place the same on record, found in order, and list after 1 week, 2 weeks,
After vacation.
after 2 weeks.
Obliged.
4.
Lordship, private respondent still not served, Lordship.
When was it? When was this notice sent?
Lordship, in the month of September.
What about the newly impleted respondent need?
Yes, Lordship.
You have taken steps.
We have taken steps on 9/9.
9/9.
Yes.
You take first steps.
First step. Lordship, may we be allowed to take dusty steps along with them?
Okay. The petition is permitted to take first steps for service of notice on the respondent number 8 by dusty service to the registry of this court within 1 week,
Lordship.
within a period of 1 week. Thereafter, the petitioner shall file an affidavit to that effect. List after 3 weeks.
Applies.
5,
May I please, your Lordship? Lordship, we need some time, Lordship, to address on the issues raised in the affidavit, Lordship. Lordship, 2 weeks time may be granted, Lordship.
To file your affidavit.
No, my lord,
Certain issues were raised, Lordship.
Okay.
no, my lord, what had happened in this case, the state filed an affidavit
Additional affidavit.
saying that, my lord, they have engaged an agency from Holland to, prepare the tender and other things. My lord, number one, this agency was selected without any tender process. That apart, my lord, on, I think, I'll just give the date, my lord. Yes. The work order for initial planning and tendering was issued on 21/8/24, my lord. Whereas the inception report was submitted on 29/24. That too without any tender. And my lord, for this only, they have spent 12 crore rupees. Whereas this work can be done by at least 1.5 crore. My lord, they have no interest to address the issue. Their only interest to just keep people informed that we have engaged a firm from Netherlands. What Netherlands do, my lord? My lord, they are only for preparing a plan. And they will take 9 months. So by 9 months, my lord, the flooding season of 25 will be still there. So, my lord, where is the sincerity on the part of the government in addressing the issue? My lord, it's not a private public it can't be treated as an adversarial litigation.
Lordship,
some urgency
Lordship,
is being
address the same, Lordship, 2 weeks time may be granted.
Why
Lordship.
2 weeks?
Lordship, in a week, Lordship, a week's time.
Okay, I'll give you a fixed date. On that day, you have to finish.
Yes.
Okay, heard Mr. K. Chaudhary, senior counsel, assisted by Mr.
Yes, you are.
For the petitioner, on request made on behalf of
Lordship, on behalf of Mr. D. Sakai.
the cycle and the Advocate General. Also. This the matter on when?
Lordship, on 18th, Lordship.
Okay. 18.
Deeply obliged, sir.
6 and 7,
He's there, isn't
My lord, there is a contempt petition and a petition against the order of the tribunal. Contempt they have complied with.
Already complied.
They have filed it, so lordship can close the contempt.
Mr. K. Chaudhary, senior counsel, submits that the respondents have complied with the directions passed by the
This honorable court, my lord.
passed by this court staff. Mr.
P. Golita.
B.
For the
Kalita,
contempt
learned
note.
counsel, appears for the sole respondent,
Sole contempt note.
sole respondent stop.
And regarding the, my lord, writ petition, it can be listed in the last week of January, my lord.
Is accordingly closed. Writ petition?
Can be listed on
Okay.
last week of January, my lord.
Yes. On request made by the parties. This is writ petition, huh? List the matter when, you want a date fix or?
Last week of January.
List the matter in the last week of January 2025.
8,
May I please, your lordship? There is a delay of 69 days in preparing appeal, lordship. The department is there, lordship.
Who appears for R7?
Well,
Respondent 7.
well, respondent number 7.
R6 notice is waived,
My lord,
but then respondent 7 is a party.
my lord.
He has received a notice. But then anybody representing R7.
Well, he has already retired, perhaps he has no interactive. Because matter
Yes.
is relating to headmaster, appointment of headmaster, promotion of headmaster.
Okay. Yes, anybody appearing for the state? You have any objections? Heard Mr. M. Khan, learned counsel for the applicant. Stop. Also heard MS K. Das. A. Das, learned standing counsel. Huh?
Number 1, 2, 3, and
Education Department.
4. Yes, sir.
For the respondents, 1, 2,
3 and 4.
3, and 4. Stop. None appears for the respond number 7, despite service of notice. Stop. By this application, the applicant is praying for continuation of 69 days delay in filing the connected writ appeal. Stop. We have reduced the cost shown in the present application and we are satisfied. The Learned Standing Council, School Education Department has also no objections. Stop. Accordingly, the delay of 69 days is condoned. Registry is directed to register the writ appeal and list the matter in issue.
9,
Service rotate मेरा दिन respond 3 to 8 मेरा. I've taken step upon respond number 4 my lord on 18/11/2024. May I pray paper publication my lord, may I pray for
Why not you take paper publication where?
in ISL my lord, because it is ISL matter my lord.
Hmm.
In one in English and one in vernacular my lord.
Okay. We can do that. We are praying for the,
Respond number 1 and 2.
okay. The applicants are permitted to cause service of notice on the respondents 3 to 8 by paper publication by publishing the said notice in 2 local newspapers having wide circulation in the state of Mizoram. Within bracket, 1 in English and 1 in vernacular. Within a period of 2 weeks,
My lord, 3 weeks my lord.
within a period of 3 weeks, showing the returnable date as 27th of January 2025. Thereafter, the applicant shall file an affidavit to the effect. List on 27th January.
I live.
10,
I is for condoning delay of 16 days. We have notice issued. Notice has been issued here.
Notice served.
That PS notification. We have filed the got the extra copies that
No AD guard. No unserved notice.
Still Lordship, the learned counsel, I have talked to him, but his name has not been shown up. I think he has not filed wakalatnama. So, but it may be taken up next week. I'll confirm.
Okay, on request made by Mr. A.R. Tabilda, the standing counsel
Higher education department.
for the applicant. List the matter after 1 week.
Obliged.
11,
May it please your lordship, as per office notated 2/12/2024, neither ready card nor answer basis has been returned by lordship. Lordship, as regard respondent number 1, lordship has been transferred to Patna to New Delhi. Kindly allow us to take first step, lordship.
You want to take first steps
Yes, lordship.
on 1 and 2?
Only one, lordship. He has been transferred Patna to New Delhi.
How about 1? How about 2?
Lordship, we have not served the notice, lordship, not returned back yet.
So you take first step from both 1 and 2.
Yes, Lordship. To his Lordship in respondent number 1 to his new address, Lordship in New Delhi.
Okay, MS,
AB Kayastha.
AP,
AB Kayastha.
Kayastal Learned Counsel for the applicant submits that the respondent number 1 has been transferred to,
Patna to New Delhi,
has
Lordship.
been transferred from Patna to New Delhi.
Yes, Lordship.
And accordingly, she prays for taking first steps on the respondent number 1 in the new address. Stop. Para. The applicant is permitted to take first steps for service of notice on the respondent number 1 in his new address, as well as on the pro forma respondent number 2 by registered post AD within 1 week, least up to 4 weeks.
12,
May I please, your lordship? Appeal, my lord, filed by the finance department. There's a delay of 263 days. It will list
Notice.
Notice, yes, my lord, I find a caveat on record. I find a caveat on record when Mr. P. Borderline.
T. Buga.
You're the caveat?
I am the caveat, my lord. I need some time to file objection, my lord.
No,
regarding
fine,
this.
fine. You are appearing on behalf of?
Private respondent, my lord.
How many of
He will be appearing for our, my lord, OP number 1 to 20. They had a private petitioners.
Private respondent.
And from 21, 22, 23, my lord, these are all pro forma respondents.
Principal, he is happy.
Okay. Heard Mr. R. Barbajari, Leonard Standing Counsel, Finance Department for the applicant. Stop. Issue notice. Mr.
D. Buga.
D. Barwal, Leonard Counsel, enters appearance on behalf of the opposite parties 1 to 20. And prays for how much time?
2 weeks time, my lord.
2 weeks time.
Immediately after reopening.
So
my
file
lord.
objections. Stop. Para. Anybody for PNRD? MS? Okay, Mr. S. Datta, Leonard Standing Counsel, PNRD appears for the pro forma respondent 21 and 22, and Mr. C. Barwa,
For 23.
Leonard Standing Counsel, Accountant General appears for respondent number 3. Stop. List after 2 weeks.
Well, here, my lord, I may be permitted to serve extra copies on the councils
yes,
since all are represented, my lord. I'm so obliged.
13,
See, there is a delay of 278 days in preparing the writ appeal, Lordship. So notice me go, Lordship.
Heard Mr. Ezekiel,
For Teshwari University.
Leonard Standing Counsel for the applicants. Issue notice. The applicants to take steps for service of notice on the respondents 1 and 2 by registered post AD within 1 week,
Not.
least up to 4 weeks.
15,
I'm sorry. May it please, my lord. My lord, the respondent took part in a selection process where his case regarding the physical measurements, my lord, was rejected because he does not have the adequate height requirement and the eyesight. And that was done by a team of doctors, my lords, which was constituted across the board. And it was a neutral, my lords, board which was set up in Agartala. Now, what he does is after he is rejected, he does not take it up with the authority. He goes behind our back. He goes to the medical hospital again, gets himself privately checked up, comes up with a parallel report saying that he meets 164. The requirement otherwise is 167. We found him to be 163. For people belonging to the hilly areas, manners, there is a relaxation given of 3 centimeters. So therefore, if he is 163, 163 plus 3 is 166, which is less than 167. So he goes privately, my lords, to the medical college again. He gets himself measured, presumably, allegedly, and his height is found to be 164.5 now, privately. And then his eyesight, which was not found to be 6/6, which is a requirement under the medical norms which are fixed by us, the doctor finds him 6/6. Then, my lords, he comes back to us saying that his initial case is that he was rejected on the ground of bow legs, which was not the case. So he files a writ before the Manipur High Court twice, and he is rejected on the ground that the jurisdiction lies before this court. He knows very well that the jurisdiction lies before this court, but he goes there, gets an order behind our back without serving us. But, my lords, rightly, the Manipur High Court says you go for the Guwahati High Court. Now, in the meantime, what happens, my lords, is that there are 4 other people who have also challenged this particular, their physical measurements. And we have said that, no, what we have found through the medical team is correct. And they have not come before the court. Now, the entire selection process is over. The selection, my lords, the list has been, my lords, created. The people have been now sent for training. Now, the single judge, my lords, comes to a, my lords, finding that based on his private reports, he is supposed to be sent to a medical board, my lords, set up by the Guwahati Medical College. Now, the problem with this course of action, my lords, in my respectful submission is that we have certain rules. The rule I have placed, my lords, we have placed the advertisement also, clearly says that when you have been found unfit by a team of medical experts which has been constituted specially for the purposes of selection, that decision is final. And everybody else has accepted it. 84 people, my lords, have been rejected on these grounds and have not challenged this. He is only one person, my lords, who is now coming before the court with some private report on his hands, challenges my lords, the team of doctors which sets up this entire process into motion. And now, my lords, the single judge says that you have to constitute a medical board. Now, if we have to do that, my lords, this will open up a Pandora's box 2 ways. One is the sanctity of my rule, because my rule clearly says that the decision is final and binding. Now, if he has a problem with that, he could have come before us and we would have sent him to the same board. But now he has come to the court, placing reliance on private reports. So 84 people, in let's say a subsequent selection process, if anybody's case is rejected, now all that the person will have to do is take the precedence of this matter and then say that now you go before a private doctor and you get a private doctor's report and he will challenge the proceedings, my lord.
Where are the 2 reports?
Where are the 2? My lord, my report is at page 21. This is not actually my report, my lords. This is a neutral body of doctors which was created. At page 21, my lords will kindly see height. The first column, my lords, the first serial number, height, 167, and my lords, 164 for heel area. He is 163. Then, my lords, will kindly come to page 23, which is the eyesight. 2 grounds, one is height, the other is eyesight. Page 23, my lord. It says it has to be 6/6. My lord sees the description, distance vision, 6/6 without glasses. My lord sees that. And my lord, his report is 6/12 and 6/18. So he does not fit the criteria. And the doctors are found to be unfit. And my lords will kindly see the observation given by the team at the bottom of the page. It says unfit due to eyesight. And then what he does, my lords, is he goes to, that report is at page 77. My lords will kindly see.
Yes.
He goes to, my lords, Jawaharlal Nehru Institute of Medical Sciences, Porampur, privately. At page 77 is his eye test, my lord, 6/6 and 6/6. He gets this report for the eyesight. The next page, my lords, page 78, is the height, 164.5. My lords, 163 in my respectful submission. My lords, these are height and these are eyes. This is not something internal. This is something completely external. So suddenly one fine day, one cannot wake up and gain 1.5 centimeters and have perfect vision. And my lords, this should have been done by him at that point itself. When my lords, he is also aware, because my lords, these are SEP norms. We have not fixed these norms. These are SEP norms in the advertisement itself. When the doctor is, my lords, measuring you, or when the doctor is measuring your eyesight, you know that you have failed. He was completely aware of this. So at that time itself, he could have gone back to the same team and said that, look here, you have rejected me on this ground and I am taller than what you have made me to be, or my eyesight is perfect. He could have been retested, my lord. And then he goes before the Manipur High Court twice. First on the ground that, my lords, he gives a wrong, my lords, submission. He makes a wrong submission before the Manipur High Court, saying that I have been rejected on the ground of bow legs. We have categorically by an email already said that no, you have not been rejected. The emails are there, my lord. My lords will kindly see page 19. Page 19, my lords will see just one email.
Yes.
My lords will kindly see page 19. His email is towards the bottom of the page, where it says that this is to bring to your kind notice that my candidature was disqualified during medical test on the ground that I suffer bow legs. And we have said no, that our answer is at the top of the page, the same email, the response. It says, my lords, it says your height and eyesight is not as per requirement, as per the advertisement. So he knew fully well. But he goes to court, to the Manipur High Court, saying that my case has been rejected because of bow legs. And my lords, in the report, my lords, very interestingly, in the report, he is not found to be having any bow legs. So he shows that to the Manipur High Court.
That is a different issue now.
Yes.
But then what is wrong with this? What is wrong with the interim order?
My lords, the problem is twofold. First, my lord, today we have already, my lords, carried out the selection process. My lords, everybody is gone for training. One. The second problem is, as a matter of precedence, my lord, we have a rule that categorically says that the decision of the medical board constituted by us is final and binding. That 10.30 is a part, my lords, of our rules. Now, if this particular order, my lords, is to be sustained, in my respectful submission, what will happen is the rule will then be given a complete go by, and he has not challenged the rule. The rule has not been challenged before the writ petition, my lord. So unless and until you challenge the rule, you cannot then, the court cannot pass a direction without finding the rule to be wrong. Then, my lords, there has to be an observation by the single judge that the rule is wrong. Please see the rule, my lord. 10.3 at page 62. Kindly see that, my lord. This is a part of our rules, my lords. 10.3 at the top of the page. Page 62, top of the page. 10.30. The decision of the selection committee is not liable for challenge, and the same shall stand final and binding on each candidate.
This one, so that we can have a look into this matter.
Because of the report, most
No, that was, and then the single bench also said it has to be done within 1 week. Not that 1 week can go over.
there nothing about interim is mentioned. Only it was interim of the part. So I don't understand how the appeal is also maintainable against that. This appeal is against that order. Whereby only
Mr. Sharma, have you served copies on the other side?
Well, there was no caveat. My instructions are that there was no caveat on the other side. Well, as my respectful submission is that
Anybody for the health department?
well, as there was only a sole respondent, man.
No. Here,
Yes.
the direction was given to the.
But they are not
one
parties,
Mr.
man.
A. Chalia. Chalia was directed to coordinate the.
Yes, as per the intent, as per the interim order, my lords, yes. But they were not parties to the petition.
Of course, that is a different thing.
So that's why they are not here. Unless the rule is found to be
And
wrong.
what is this? Interim order passed early to continue till then?
My lords, there is an interim order passed previously on the, my lords, 15th of October.
What
that says that
interim is
one
that?
seat has to be kept. Now that one seat we could not keep in the he belongs to general category. Now this is the other problem, my lord. He goes to Manipur twice. He comes to the Guwahati High Court at the last occasion. By then the selection process is already over. We've already said so in our counter that, my lords, before the single judge, we pointed it out that the selection process is over. But in deference to the court, my lords, we have kept now, incidentally, have taken instructions, one seat in the reserve category. That is also going to be a problem going forward. We had to, my lords, bow down to what the direction of the single judge was. So we have kept a, my lord, seat, but then that is in the reserve category because all the general category seats have already been given. The select list came out, my lords, by then. He came to court after the selection process was over.
No, the interim order was to keep one seat vacant.
We have kept it.
For which?
For the
which
petition.
category?
My lord, there was no mention of any category, but because we had already given all the seats in the general category, that by then it was already done. In order to comply with the order, we have kept one seat, my lords. There was one category, one reserve category seat, which was still vacant. So we have kept that, my lords.
No, is the petitioner does the petitioner come under the reserve?
He does not.
The unreserved?
He's unreserved. He's general category.
Total
Then that is also going to be a problem.
So how can you have a?
My lords, that is also going to be a
How can you have a seat reserved in the reserve
My lords,
category when
this is my
the
instruction.
petitioner is from the unreserved category?
Sharma, you have not even challenged that order of 1510.
We have not challenged
In
that.
this appeal, you are only challenging the
Yes.
subsequent order where
My lords.
the has been directed to appear before the
Lordship, please.
committee.
Yes, my lord. My lord, the reason was that we were under the assumption, or my lords, we were under the bona fide belief that the court will not pass this particular order subsequently, will permit us to, my lords, argue the matter on merits. And then, my lords will kindly see the order also. I will just show my lords the order at page 85. My lords will kindly see
I
that.
don't think they have.
Why we did not challenge, my lords? That it's a pertinent question that my lords has raised. My lords has raised the
Mr.
pertinent
Sharma,
question. Yes,
what is wrong in this order that two contradictory reports? The petitioner has come before a writ court.
yes,
The court just wants to verify.
My
Therefore,
lords.
it has been sent to the
yes.
medical team.
My lords,
Can you object
I
to
understand
that?
what is falling for
Now,
my lords.
Appeal is maintainable against that order. This is not an interim order also.
Yes, in
How is
effect,
this appeal maintainable?
in effect, my lords, the reason why we did not challenge that earlier order was because since my lords asked me that question, the next order which was passed said that we will dispose of the petition finally at the stage of admission itself.
Fine.
But then not doing that, my lords, this particular order has been passed. So therefore, to answer what my lord Justice.
No,
Gaurav
what is
asked
wrong
me-
with the interim order? Maybe the report will come in your favor.
My lords, then I have a submission, my lords, if it appeals to my lord. My lords, this medical board has been constituted with the doctors of GMC. We have not, my lords, been made a party, or my lords, we have not been given the opportunity to be present
No.
when this is carried out.
That is. It's
Because unless we are
it's an independent body,
yes.
and the independent body will take its own course.
No, we are not going to interfere with that.
No, you are
We
not.
will not
supposed to
interfere with that. I am not even for a moment saying that let us be a part of the body. No, at least allow us to be present, my lords. I am not saying that let the body which has been constituted, let it take its course. I have no problem with that. But today he has been independently asked to present himself separately. Through, my lords, have already seen the Ministry of the
No,
Health.
whether the board has been constituted.
My lord, at this moment, I don't have the inspection, my lord, and what is what. But I can obtain the inspection if your lord.
Because see, the direction was within 1 week.
Yes,
my lord.
1 week is over.
Yes.
1 week is over.
Almost.
So whether the board was constituted and whether the petitioner was or the respondents carried was examined.
I can obtain the inspection, my lord.
Well, unfortunately, I'll also not be able to assist the court because we have not been, my lords, permitted.
Oh, no, that's fine. We'll take up on Monday then.
Yes, my lord. But the details, my lord, I have to be provided.
Yes,
my
yes, we'll provide a copy of the petition.
Provide a copy. Heard, Mr. C.B. Shamal and a senior counsel, assisted by Mr.
D. Dekal.
D. Dekal and a counsel for the appellants. Stop. Para. Though the health department is not a party, in the present appeal. However, in view of the directions passed by the learned single judge by the order dated 28/11/2024, we request Mr. B.B. Bora, the learned standing counsel health department, to take instructions as to whether the medical board, whether the GMCH has constituted the board and examined the petitioner in terms of the directions passed by the learned single judge. List the matter on 9th.
I'm obliged.
Obliged.
16.
My lord, in the cause list, standing counsel help may be shown.
You are not a
Yes,
party here.
Please, your lordships.
Oh,
The petitioner before your lordship has a limited prayer, is just asking for some time to make the payment. Admitted, the petitioner is a defaulter. His account has been made a distinct non-performing asset on the 23rd August 24.
okay.
Although he has deposited the amount within with a difference of some fraction of time, some hours. Thereafter, he has already made some payments also, but those amounts were not adjusted, and then the respondent bank is asking the petitioner to pay an amount of rupees 71 lakhs 19,156.86. Whereas the balance should have been 56,90,700. As because the petitioner has already paid an amount of 14 lakhs 28,456. And the last notice being issued on 25th November 24 under section 13(8) of SARFAESI Act to redeem the secured asset. So
Page
number 31.
When we entertain this petition. Can we entertain this writ petition? In view of the
Petition is available for DRT, but the petitioner is before your honors
in-
because
Supreme Court has already passed a direction that we should not entertain this. This sounds
Lordship, I'm just praying for some time only to allow me some time to make the payments. I'm ready to make the payments, and then they have rejected my distinct prayer for.
They have challenged indirectly the SARFAESI action of the bank. And for that, the alternative remedy is at debt recovery tribunal. So many judgments of this on it.
Plus Supreme Court also.
And Supreme Court 2024 recent judgment.
I think you should approach the DRD.
We have taken the possession only on 16/11, symbolic possession. So they have 45 days in their.
So you have time. You have time, why not you approach? You, instead of we dismissing this,
yes,
you can withdraw it with liberty to approach the appropriate form. MS MKG, learned counsel for the petitioner, prays for withdrawal of this writ petition. With liberty to approach the appropriate form, Mr. M. Sharma, no? Mr. M. Sharma appears, learned standing counsel appears for the Canara Bank.
Yes, Lord.
With petition is accordingly disposed on withdrawal with liberty expression.
17.
You have time.
It will be till 16 December only. So like I have just 1 week.
You have time.
Public.
16/11, 16/2. We have up to December 30.
My lord, this public interest litigation has been filed.
Okay. List this case before any other bench without one of us, without bracket, justice.
All right.
Goes.
19.
EC request.
Lordship, this is a PIL pertaining to regulation of home care service providers, Lordship. The foundation, V4 Guwahati Foundation, which is petitioner number 1, works with elderly population, children with disabilities who generally have
Are
to.
you appearing in person?
Yes, Lordship. I'm responding, petitioner number 3, Lordship. I'm appearing in person.
Yes, what is this for?
Lordship, this is for regulation of home care service providers, Lordship. So any form of allied healthcare service that any person who may be a sick person, infirm person, a person with disabilities, and generally elderly person who may not have any caregiver attender, and they may not be able to take institutional support by going to a nursing home. They generally look at employing someone who is a home care service provider, Lordship. And as of date, there is no regulation pertaining to this. And the problem that exists is most of, for instance, if I have to look at employing any home care service provider.
What are your prayers?
Lordship, our prayer is one, to regulate, to bring a regulation for home care service
Can
providers.
we grant those prayers?
Lordship?
Can we grant the prayers that you are seeking for?
Yes, Lordship.
Have
To
to
the
satisfy this court.
Lordship.
You'll have to satisfy us whether
Yes.
the prayers made by you can be granted by this court.
Lordship, first, if I may put forth, Lordship, we had initially reached out to the government through our representation also, and in the representation was dated to 2nd February 2024, Lordship. This is in the annexure A of our PL, Lordship. And based on that, we had also received a response from the government that the government is inclined to look at this issue of unregulated home care service providers, Lordship. At the same time, Honorable Supreme Court took a similar matter, but a different matter relating to allied healthcare regulations. And in the Supreme Court order, the Supreme Court has said that this particular industry of allied healthcare service providers remains unregulated, and there is a need for regulation to come in. That is
What is
something
that order?
the Supreme Court.
Where's that order?
The Supreme Court order is not a part of our petition, Lordship. I may be granted liberty to bring a short note where I can annex the order and submissions there.
Okay, on this request only. Okay, on request made by the petition number 3 in person, appearing in person. At least 1 week will do, 2 weeks.
2 weeks, Lordship, would be helpful.
After 2 weeks.
That's correct.
20.
May I have lordship? Lordship, matter pertaining the area pensionary benefit with effect from 1998, lordship. So here, lordship, the appellant father was promoted in the year of 1998.
This is already admitted. Come up for hearing. This has been already admitted, hasn't
Yes,
it?
lordship.
Did it come up for hearing?
Yes, short date can be fixed, lordship, because lordship 1998, lordship.
Is it 2024 matter?
Yes, lordship, but promoted in the year of 1998, lordship. And the appellant father was.
This appeal was admitted on 21/10/2024. List the matter for hearing. After 2 weeks.
2 weeks, lordship. Well, date can be fixed, lordship.
No.
After vacation, lordship, any of the date, lord. 1998, lordship. January, any of the date, lordship. Second week, third week.
After 2 weeks, on the date to be fixed by the registrar.
Yes, must have, lordship.
21.
Appeal filed against the impugned order dated my lord 39/2024, passed in WBC number 5963/2022, my lord. The petitioner is the appellant is the second wife, my lord. My lord, she has 2 minor sons, and there is no any income source. But first wife, my lord, she was the Anganwadi worker and now retired and drawn the pension, my lord. And thereafter, my lord, her, my lord, one son is a government service holder. Moreover, my lord, more or less 20 acres of landed property left by the deceased husband, my lord, and 2 katas of land in the municipality where from she's getting the tenant also, rent also, my lord. And after death, my lord, on 2021, my lord, the second was driven from the house of the matrimonial house. So, my lord, she is apprehended that after if she, the first wife drawn the family pension in her name, she never will provide the pension to the second wife. That is why she filed one representation before the director as well as my lord. District elementary office, block elementary office also, my lord, to provide the 50%, my lord, family pension. But that was also not considered. That is why I filed.
You are the second wife.
I am the second wife, my lord.
What is the law with regard to the first wife?
Well, that is why, my lord, the first wife is the.
That law is already settled by this court.
They said by that way, if she drawn the pension in the name of the first wife, my lord, she never provide the pension to the second wife. That is why I filed this, my lord. Instant appeal against the imperial order. Only pays for 50% family pension directly. After sanctioning the pension, 50% she may be allowed by the first person and 50% may be allowed to the second wife directly. This is my humble prayer. First wife have the sufficient income, my lord. Her one son is a government service holder also. And sufficient movable properties. When after death of the first husband of the my lord, second wife, she is driven out.
Who's appealing? There's nothing wrong.
Exactly the reason they come and pay. That's right.
Well, the 173 it only says that surviving of the first wife of the wife, my lord, first wife will draw the pension, my lord. Here is given, my lord, I agree with the second of that. If the first wife drawn the entire portion of the family pension, second wife will deprive. As because, my lord, at the time of death, my lord, husband of the second wife left 20 acres of immovable property, more or less, and 2 kathas of.
You are going against the settled position of law. This is the problem that we are facing. If you want to remove that hurdle, you can bring us. But then it's already a settled position. A full bench of this court has already taken a decision. Beyond that, what can we do?
Only, my lord, only make a direction to consider the representation page 77 to 78.
That's it. Dismiss it. We'll dismiss this petition. Appeal.
If it is not considered, my lord, then the second wife will deprive, my lord.
You want to prepare, come back some other day, that's a different thing. Otherwise, you want to argue the matter today, we are dismissing it. Or you want to withdraw it, you withdraw it. It's up to you.
In matter may be fixed in the another day.
Okay. On request made by Mr.
B.
B. Snub, the counsel for appellant. List after 1 week. Okay. MSS Chutial counsel appears for the school education department. And Mr. B. Sharma, Learned Standing Counsel, appears for the Accountant General Assam.
Or respondent.
And S. Sharma, Learned Counsel for the respondent.
37 of supplementary leave.
Okay.
Lordship has heard the other day, Lordship, that one page was missing that.
303.
303, Lordship.
You have replaced it?
Yes, Lordship.
Yes.
And Lordship,
We can issue not
head assistant is a
stadium. Where's the impute order?
Lordship.
Page 251, is it?
251, Lordship.
Okay, heard Mr. P. Chakavati, Leonard CGC. For the petition. Stop. Issue notice. Mr. S. Chowdhury, Leonard Counsel, enters appearance on behalf of
1 to 12.
all
the
the respondents. According to notice and respondents are complete. You want extra copies?
Yes, I have.
You have. Also. You want to file any objections? Nothing.
Actually, no required. Okay.
Okay.
File.
Okay.
Otherwise,
List the matter after
After view vacation.
after 3 weeks. Stop. In the interim, Mama, the order dated 17th May 2024 passed by the Learned Central Administrative Tribunal Guwahati Bench in OA number 040/0021 6/2019 shall remain suspended till the next year.
22 of Delhi Lit.
Lordship, this matter is already in the hearing list. When it was taken up for hearing, it was noticed that it was not admitted. So Lordship admitted 2019 matter fixed immediately in the month of February. Just for hearing.
Okay. It is not admitted.
Not admitted. And because of subsequent development, we have to add the university.
Heard
Lordship.
the learned counsel for the parties, admit, comma, list the matter as all parties are represented, list the matter for hearing.
In February? February?
In the month of February 2022.
23.
Yes, you file your affidavit.
Yes, sir. We have already filed our affidavit.
When did you file it?
Lordship.
Your R4.
Lordship, I am for 2, 3, 5, and 6, Lordship. AAC.
So R3 has filed.
Yes, R3 have filed, Lordship. On 1/6/2023, Lordship.
Oh. Okay, none appears for the petitioner. List after 2 weeks.
29.
My lord, the matter relates to a selection of a principal of a higher secondary school mill. My lord, initially, my lord, when the selection took place, the appellant's case was not even considered. So aggrieved, my lord, we filed a writ petition. The purported selection made in favor of respondent number 7 was interfered and fresh selection was ordered. Now, in the order that your lordship will kindly see, order page 70, my lord.
Counter has not come. No?
At page 73, para 10.
Wow.
Accordingly, the present petition is disposed of by directing the respondent authorities and state selection board to examine the claim of the petitioner and verify the same, and after making necessary verification, if it is found that petitioners had requisite 17 years of teaching experience, clubbing together this experience in the high school and higher secondary school, in terms of the clarification made by this court in WPC number so and so, the recommendation made by respondent number 4 dated 16/2/2019 will be liable to be set aside and necessary direction be issued for reconsideration of claim of the petitioner. Now, pursuant to this, my lord, a reconsideration was done. If your lordship, now what happened, my lord? Reconsideration was going on. In the meantime, my lord, the respondent number 4 filed a writ petition, which your lordships will find at page 46. And the operative portion is at page 150. Para 10, my lord.
150.
Yes, my lord.
Yes.
Having heard the learned counsel appearing for the parties and considering the pleadings of the parties, including the affidavit filed by respondent number 3, and on perusal of the materials available on record, this writ petition is disposed of with a direction to the concerned authorities, including respondents number 2, 3, and 4, to complete the process of selection of principal of so-and-so in terms of OM and Rule 13 of the rules, and decide the matter finally, taking into consideration recommendation of the selection board dated 16/2/19. You know, this was ordered to be interfered with, my lord, at page 73, which I read just now. Now, what has happened, my lord? Now this order is stayed. As a result, what happened? My consideration is on hold, and the private respondent is holding the in charge.
Oh.
So my humble submission is, my lord, the direction given by at page 73, that should be carried out in the meantime. That they are holding, my lord. Now, on one hand, this judgment has come up, my lord, where this has already been interfered with. So therefore, my only submission at this stage is, my lord, the direction as given in, my lord, judgment dated 19, sorry, itu order আছিল না আগৰ অৰ্ডাৰটো
Yes.
73 and 74.
এইটো ordered 9/12/19, my lord, in WPC 4988, that should be given effect to, because that 16/2 was interfered with, my lord. If a lordship would kindly come to 73 for a moment. Para 10 again, my lord. Accordingly, the present petition is disposed of by directing the respondent authorities and state selection board to examine the claim of the petitioner and verify the same. And after making necessary verification, if it is found that petitioner had requisite 17 years of teaching experience, clubbing together his experience in the high school and higher secondary in terms of the clarification made by this court in so-and-so, the recommendation made by respondent number 4 dated 16/2/19 would be liable to be set aside. Now, my lord, this order, this direction has been sought to be again implemented. Now that is under appeal, it is stayed. But nothing is progressing, my lord.
For respondent 7, anybody?
Court, please.
Last occasion also time was taken.
Yes. And if your lordship would kindly come to page 74, my lord. Now, on the basis of this, the consideration is going on now. Page 74. Now, kindly see Gopal Kakoti, he is the appellant. He has been given 18 marks, and the respondent number 4 is 17. After redoing the exercise in terms of the order of 2019, my lord.
Respondent 4 is still 2.
Yes, my lord.
Oh.
So my humble submission is, my lord, the direction given in that should go on, because that is attained finality.
Respondent 7. Last occasion 1A Deka.
Actually, my lord, they are enjoying that in charge, so they are not interested. So, my lord, that process should be concluded. Let whatever status is obtaining, let it obtain, my lord. Let the decision be taken shortly, my lord.
Because normally he's always.
আচলতে বুজিছা নাই ভুল কৰি পেলাই সেইটো কৰি দিয়ে আগৰ অৰ্ডাৰ
Majumdar, you are for the education? My lord.
Gopal ki?
In fact, my lord, government is proceeding in the matter. Then that judgment came. That is why now everything is in hold. Now that judgment has been stayed, my lord, while issuing notice.
But R7, where's R7?
My lord, last occasion they were present. They prayed for time also.
That's correct.
Counter is fine, no.
No, no. Well, it's a writ appeal, my
No,
lord.
but I find there is a prayer.
Prayer, correct. Well, that will not prejudice anybody, my lord, because he is holding.
Only problem is since the R7 is represented, council is not here, so.
And I leave it to lordship, my lord, or it can be taken up. 11 তারিখে লওঁ 11 তাৰিখ কি বাৰ হ'ব let it be listed on 13th. 12th I have some difficulty. Is a Friday.
Is okay. Okay. Heard Mr. Ken Chowdhury, London Senior Counsel, assisted by Mr. Ellen Dihinkiel, London Counsel for the Appellants. Also heard Mr. R. Majumdar, London Standing Counsel, Education Department. None appears for the respond number 7. List on 13th.
35 hearing.
Please, Lord. So in this case, I'm appearing for the appellant. Actually, the matter escaped my notice because my name was not reflected. I pray that matter may be taken up for vacation, Lord.
After last week of January.
You on a date or no date?
No date.
Okay, on request made by the parties. List the matter in the last week of January 2025.
See, item 36, probably Justice Goswami not like to take up this matter.
Is it?
Order date.
Swami is a.
Yes.
16 order dated 16/6.
Senior counsel.
Okay. Without him?
Yes, Lord.
Please discuss before any other bench without one of us, we don't break it. Justice?
Much of.
Deep low. Finish. Good. Single bench. Okay, 8-2. I'm not interfering with the notification which petition has been transferred.
Obliged.
We'll get it in half an hour.
Obliged.